Well, I grew up in New England, in Rhode Island. I studied at Harvard for many years, studied chemistry and then law. Subsequently, I have practiced law since 1973, although I stopped doing legal work in courts several years ago because I thought it was not very effective given the nature of our court system. And I tended to concentrate on cases that dealt with constitutional principles. Doesn't mean you always get a constitutionally based result, but at least you try to litigate those issues. And then for years I have been dealing with monetary law as one of the areas of my interest, the Federal Reserve System, particular history of the development of not only the area of coinage and currency, but the banks, and especially the central banking system. And then more recently, I've become interested in revitalization of the constitutional militia. And there I emphasize the word constitutional. I'm not talking about people that are forming their own private.
Okay, well, I tell you what, when you got to that point, let's just talk about that. Tell us what you mean by that.
Well, if you go to the Constitution of the United States, I mean, that's where the word constitutional leads you. You'll see that these things are called the militia of the several states. They existed from the early 1600s in the colonies through the independent states after 1776. And then they were incorporated in the Constitution, and actually as well in the Bill of Rights. It's interesting that that's really the only area in which the Bill of Rights overlaps the Constitution with specificity, because you have the militia discussed in the Constitution, and then of course you have the militia discussed in the Second Amendment. Now, what were these things? If you look in the Constitution, you'll see the term militia of the several states, a militia, a well-regulated militia, but the Constitution doesn't define any of those terms, and that's because the Constitution wasn't meant to be a dictionary. There are some terms that are specifically defined. Treason is specifically defined. Very good example if you look at Article 3. The reason being that under English law, the word treason was very broad. The English system had invented all sorts of definitions for activities that were considered treasonable. And the Founding Fathers wanted to cut that down significantly. And the only way to do that was to come up with a new and specific constitutional definition of treason. And similarly for Congress, the House of Representatives and Senate, there had been a Continental Congress under the Articles of Confederation, so they had to be clear that this Congress, Constitutional Congress, would have different structure and different powers, and so they defined very clearly what the structure was in the House and the Senate and what the powers were in Article 1. And that's similar for the President of the United States. President was an office that hadn't existed previously, so they go into detail about what powers and duties the President will have. Well, when we come to the terminology militia, there's no definition there at all. And the reason was because for 150 years, these things had existed in every one of the colonies, and the people who were writing the Constitution went to the Federal Convention, 1787, the ones who attended the state conventions thereafter, and all the people who were, certainly who were adults at that time, knew perfectly well what the militia of the several states were in their own states, because most every one of them had served or was serving in a militia structure. Now, what happened subsequently was that those structures, what shall I say, they decayed through a lack of public participation and interest through the early 1800s. By the time you get to the 1830s or so, you begin to see states such as Massachusetts making their militia no longer compulsory, and that was one of the first I would say constitutional breakpoints, unconstitutional action, actually, because if you look at the history of the militia in the colonial period, those institutions were always compulsory. There was no way out of them. You could get an exemption from certain kinds of duties, but everyone was considered to have some kind of responsibility to participate. Then, of course, along comes the war, 1861 to 65, and a tremendous amount of bloodshed, and actually militias did serve in that war on both sides. But subsequently, people were pretty sick of bloodshed, and once again the militia structure atrophied and became essentially social, charitable. It tended not to have any kind of broad-ranging membership or significance. And it's interesting that out of that period, in fact, developed an organization that we all know, I think, today, the National Rifle Association, which actually isn't connected with any militias, but it was formed by the Union General. I believe Dan Butterfield was the leading former Union General, who was concerned that what he saw in the Civil War led him to conclude that at least the boys on the Union side couldn't shoot straight, or at least not too often. And he thought that it would be useful to have training for the great mass of citizenry, so if they ever needed to be called up for a major conflict again, they'd be at least in a rudimentary state of training. And that's fascinating because that was what the militia had always done. So the thing had atrophied to the point that this Union General thought it was appropriate to found a private organization to promote that kind of training. Well, then we go to 1903, which was the beginning of the National Guard structure, which was set up really in an attempt to supplant the militia, because it had been determined at the turn of that century, turn of the 20th century, that as a legal matter, the militia could not be called up to fight in foreign wars. The Constitution only allows them to be called up to execute the laws of the Union, suppress insurrections, and repel invasions, and foreign wars don't fall into any one of those three categories. So,
okay, I got a question for you, Dr. Vieira. So what you're saying is the National Guard has absolutely nothing to do with the term militia.
Well, it's certainly not with the constitutional militia. It's an adjunct of the Army.
Okay, I understand that.
Or the Air Force. You know, they've broken it up now, but originally it was an adjunct of the Army to provide a very large trained reserve force, and they structured it on a state basis. I think because either some of them were confused, or number two, they wanted, in a sense, to cover what they were doing, and thirdly, they wanted to have state support from the state politicians, so the federal government gave a kind of a fillip, if you will, to the state political structures in this. But in any event, that was 1903 when it began, a statute called the Dick Act. And then comes 1916, which was the National Defense Act, and by then they had gotten everything up sufficiently so that large numbers of National Guard people were sent off to World War I. Well, obviously World War II, the National Guard participated in every war or non-war, Korean police action, Vietnam War. I mean, none of these things were declared wars, but all of those military activities, National Guard was involved. But they were all involved as adjuncts of the Army or later the other services. So if you look at today, in just about every state in the Union, and also at the congressional level, what you find is some statute somewhere, which, and certainly the congressional level is a good example, it defines a thing called the militia of the United States. And I love that definition, or that statement, that term, because there's no such thing. It's typical of Congress. You can't find in the Constitution anything called the militia of the United States. There are the militia of the several states. There's a militia in each one of the 50 states constitutionally. So the Congress couldn't even get it right in terms of the terminology. But then they break it up into two categories called the organized militia, which is the National Guard and the Naval Militia, adjuncts of the armed forces, so they're not militias. They got that one wrong, too. And then the other one is, the other segment of that structure is the unorganized militia. Well, constitutionally, there can be no such thing as an unorganized militia. In every one of the colonies and states, the militia were always organized, and they were organized to the extent that everyone was in the militia. You were a slave, because of course they had slavery in those days. Unless you were a slave, or unless you were a woman, because women were not emancipated, they were subject to their husbands or to their fathers. And also, social customs in those days did not look with favor on the idea of women serving in some kind of quasi-military capacity. So the women were out for that reason, and the slaves were out for another reason, but everybody else was in. From 16 to 55 or 60 years old, and that upper age range was primarily a matter that when people got to that age, they were really superannuated. They had rheumatism, arthritis, the heart disease, physical failings that couldn't be cured, couldn't be dealt with, and so they couldn't perform the functions. It wasn't a matter of some kind of arbitrary number was picked. These people simply couldn't perform. End of discussion. So everyone was organized in some way. Some people had exemptions because they fulfilled particularly important other functions in society. So if you were a member of the House of Delegates, you were a member of the legislature, if you were a judge, if you were the governor, although the governor tended to be the commander-in-chief of the militia anyway, if you were a sheriff, you were a constable, so that you needed to be on duty in those offices on a regular basis, you were generally given an exemption from most of the militia training. That didn't mean you might not have to have a gun. That didn't mean you wouldn't be called out in an emergency. But generally speaking, you'd have an exemption from normal training. Same was true of people in private occupations that were of great consequence. Physicians tended to be exempted. But, of course, they wouldn't have been exempted if an alarm developed, an emergency situation where the militia was called out. They served. Ministers tended to be exempted because of their calling. But, of course, you know, the first man who showed up with a gun at Concord on April the 19th of 1775 was the town minister. So you see how far that exemption went. Typically, they exempted ferrymen and millers because those categories' activity were vital functions in that society. You had to have someone to run the ferry because it was a transportation grid, transportation, the neck of the funnel, if you will. And you had to have someone to run the mill because they were agrarian-based societies, and the mill was a vital part part of their production structure of food. So that's the way it was organized, and it was organized, besides saying, well, these people are members, it said, point number one was everyone was organized. Point number two was everyone had to be armed. And you were required in every statute, in every colony and state, to buy your own gun out of the free market. So it presupposed a free market in guns, and it presupposed people would buy and own and possess in their own homes their own guns and ammunition. They had a list of other things, maybe a bayonet, maybe a tomahawk, a sword, whatever, depending on which statutes you were looking at, or whether you were in the infantry or in the cavalry. But everyone had to have a gun of one kind or another, and ammunition.